Welcome to the Roetzel HealthLaw HotSpot. HealthLaw HotSpot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the HealthLaw Hotspot. Today, we're going to be talking about what every practice should be doing to have a very solid compliance program and to prevent audits from occurring. I'm happy to have with us today Elizabeth Hylton, and I'll make the introduction shortly. First, I'm Ericka Adler, shareholder at Roetzel and Andres and head of the HealthLaw Group, and I'm joined by my colleague, Christina Kuta, who's also at Roetzel and Andres and a member of the HealthLaw practice. Elizabeth has joined us before, and we're really excited to have her back with us again. She is part of the American Academy of Professional Coders. She's their regional director and specifically works in audit services. She previously joined us to talk about how to respond to audits when a practice receives them. And today we're having her here to talk about kind of the opposite end of that, which is how to prevent audits from occurring in the first place, how to prepare and educate your staff and have a really solid compliance program. So thanks for coming back. And why don't we start with you just talking a little bit about what you view as the most important features to prepare your practice from a compliance perspective.
Sounds good. Well, I'm happy to be back. And this is kind of where I get really excited because I am all about starting these relationships with our different clients. Really, the most important thing is you have to have a starting point. You have to figure out where you want to start. It is very, very difficult for some large organizations to say, yes, this is exactly where we want to start because their scope is so big. If you're a smaller practice, you may, 1, 2 providers, that may be much easier. You could just say, okay, we're going to look at a sample of 10 charts and we're going to include 3 99213s, 4 99214s, and then 3 99205s if we can find them. And you go from there. If you are a bigger practice, you may start to get into looking at national bell curves. How do your providers stack up to others of their peers across the nation? And then using that, you can really hone in and do some data mining and discover, okay, this is the predominance of my provider's practice. What are they actually doing? So finding your sample, I think, is going to be the easiest place to start. Figuring out what is relevant to how your provider practices and where the biggest areas of risk for your organization lie.
Okay, great. So you're talking about going in and talking with a practice and saying, hey, why don't we make sure that everything you're doing is right?
Mm-hmm.
And what you're really thinking of is this is a good sampling to kind of get a sense of where you guys are. What do we need to help you with? What are you doing right or wrong? Now, last time we all got together, we talked about the fact that when you do an audit, you really want to do it through legal counsel. Christina, how do you advise your clients when they're just doing some kind of routine compliance? Do you also recommend that they're still going through legal counsel? And can you speak to that topic?
Absolutely, yes. I still always recommend that clients engage in a third-party auditor through legal counsel, even though it's not the same as responding to an actual audit that came from the government or commercial payer. You still are looking through records and billing and compliance concerns, and the whole point of it is to try and discover potential issues before you get an audit from the government or commercial payers. So it's still very important, I think, to keep that attorney-client privilege. So if you do discover errors or discover that someone in your practice is acting inappropriately and maybe in a purposeful way, then you're able to sort of keep that under the attorney-client privilege umbrella and work with your counsel and the auditor to decide how you respond to that and what needs to be done to address what you found. So I think it is definitely equally as important. And it's also a good way to keep good relationships. We have clients that every year or twice a year work with the same audit company. We're always brought in to engage them, and we've sort of all created a relationship where now if there is an issue with this client, we all know each other, we all know the work that we've done for the client over the years, and I think we can work better and more impactfully to assist the client if there is a concern.
So once you kind of done that initial audit and you say to a client, well, now I need to get to know you. Let's look at some of your records. What happens at that point? You get together, you talk with the lawyer and you say, look, and when I've been on, this kind of work, I get a report, let's say, that tells me everybody's error rate.
Mhm.
And then we kind of talk about what kinds of things were they doing wrong. So once you have that out there and you kind of see what they were doing wrong, what do you recommend as the next step?
Well, obviously, if you identify things that need to be fixed, we're not going to have a meaningful improvement unless that gets communicated. So, getting everyone around the table and saying, all right, these are the areas that we need to address. That will help foster relationships not only between the administrative folks like you and I with the provider, but also get the provider talking to their staff. And a lot of people, this is where I lose them because they say, nope, I'm not having that conversation with my provider. He's scary. He doesn't have the time. No way. And that shouldn't be the case at all. One of the best parts of my job is speaking to the provider, fostering that trust, because providers know that coders and auditors and legal professionals, they hold the purse strings, and it is very, very important to have their cooperation and their support because they can be the most productive provider in the United States. But if they do not know how to bill for their work and document to support it, they're not going to get paid. So having those very frank conversations and saying, we're here for you, not to punish you, couching your message in such a way that they understand we're advocates for them instead of the police, as it were, then you can foster really open communication, trust starts to get built, and they're more inclined to listen to what you have to say.
So would that kind of be talking about you need to write your notes in a more thorough manner like this? This is when you would use a level 3 versus a level 4.
Mhm,
Your notes don't support the level that you're choosing. So do
mhm.
you then spend kind of one-on-one time, or if it's a common issue, spend time explaining these kind of issues
Mhm.
to them? Um,
Yes, we offer both. We actually will do one-on-one training if it's the provider's preference, and I will sit down and have their notes in front of me and say, okay, so this was billed as, I'm going to throw out an inpatient code. This was billed as a 99223. We coded it as a 99221. Family history is not documented, or it's documented incorrectly. For that reason, we had to downcode, and this is the highest level that we can possibly support. You can fix this by changing your wording because they may put language in there like family history is non-contributory. A lot of our MACs do not allow that type of language. They want to see some sort of review, and non-contributory just doesn't cut it. So a better terminology to use for this would be family history reviewed and is not pertinent to clinical presentation at this time. You're saying the same thing without actually saying non-contributory. That's a buzzword that MACs do not like to see.
But that just seems like a lot of administrative hassle, which I guess is
Mhm.
part of what doctors complain about when it comes
Yes.
to the EMR. So
Mhm.
once you sit down with them, you tell them, look, these are some things you need to work on. What's the next step in your relationship? Do you say, try and implement these changes and then we'll do another audit in six
Mhm.
months? Or is there
Yes.
anything else that happens? That's
It
pretty
is.
much how it works.
Yeah, it is very much a cyclical thing. We start with our baseline, we educate, audit, educate, audit, educate, audit, and we do it until the provider has got it and it's sticking and they're comfortable with the changes that we have proposed. We're comfortable that they are now meeting the benchmark that is appropriate for the industry. And, you know, we're always available to provide support. And I've gotten to the point with some of my providers where they will literally just pick up the phone and say, I've got this patient in front of me. I'm waffling between this code and this code. Which one am I going to pick? And we'll actually walk through the note with them at, live right there with them. And they really do appreciate having consistency in that kind of program. If you build a rapport with someone, you perform an audit, you educate, you come back and audit them again, educate again, eventually they are going to build confidence in you as a professional. You know your stuff, you know what you're saying, you know what you're talking about. And of course, your approach to them is very, very important. Recognize they're a busy professional, build the rapport, make sure they understand you are their advocate.
Great. And do you see, sometimes I have one group in particular that gets audited every year, every 6 months, and I still don't see them getting like 100% correct. They still are like in the 60, 70 percentile. So, I mean, they're very smart. They're being educated. They're the
Mhm.
same specialty. I mean, it's not like they're switching between specialties. So why do we see that happening?
It can be a number of different factors. It can be the fact that old habits die hard. It can be very, very hard when you are in the heat of seeing 30 plus patients a day and you're busy and you're trying to get all of your documentation done and still go home and sleep a few hours before you have to get up and do it all over again. We know that our providers have an immense burden when it comes to both their practice and satisfying administrative rules. It could simply be that there are just not enough hours in the day. They could also be in a situation where their documentation tools, their electronic medical records, et cetera, are really making their job more difficult than it needs to be. So they just throw their hands up and they're frustrated and they don't want to listen to what we have to say. Or it could simply just be, well, I don't have to listen to you. And then it becomes a completely different conversation. Well, you either listen to me or you're going to listen to someone who has more clout than I do. And trust me, you do not want to go down that road. Nobody looks good in that color orange, if you get my meaning.
I get it. And I think, what about the allocation of responsibility? Do you see more physicians kind of completing the medical record and then somebody on the billing staff is actually doing the entry and the coding and stuff? Is that a good way to divide it up, or are there more mistakes when you do it that way?
That could go one of two ways as well. Again, if there's the rapport that exists between the coder and the provider, where potentially the provider reports something at a higher level than what documentation supports, the coder should be comfortable enough to go back to the provider and say, this doesn't pass muster and here's why. Now, alternatively, especially when you get into some of these specialties where they may be billing out these very complex surgical procedures, coders may be assigning codes and they don't have the knowledge base to come from. Again, talk to your provider. Make sure the provider is documenting in a concise fashion so that the coder can then come back and look at the note and go, yep, this is absolutely what he did. I don't have any problems billing this out and we're all good to go. So I think it's a successful model to have a coder in place to code claims as long as there is dialogue between them and the physician. That's a multi-layered thing.
Christina, when you're looking at helping our clients build their compliance programs, are there recommendations that you tend to make as well as being part of this program?
For sure. I think, one of the first things we always recommend is to engage a third-party auditor and to do it routinely. So once a year, twice a year, sometimes 3 times a year, depending on the, difficulties of the practice or the specialty of the practice, I think is first and foremost. I think the other thing that we generally recommend is that there is a response to the audits, that you don't simply just get the audit to say, oh, okay, we do compliance audits, that you actually pay attention to what came back in the audit and will go ahead and make changes in your practice that reflect some of the issues the auditors may have found. I think one of the other things that we always need to talk about from a legal perspective is if you find an issue, what is your responsibility at that point? With the auditor, their goal is to educate you and make sure moving forward that you're doing things appropriately. And that's, I think, the legal counsel's goal in assisting the practice as well. But the other piece of it is to look at what the responsibilities are if you find a problem. Do you have to self-report? Do you return money to the MAC? Do you have to make an OIG report? What do you do when you have discovered on a compliance audit there's been an issue? And we've talked a little bit about, some of the difficulties with, sometimes providers are very busy or they don't maybe want to listen to the education. I've had those experiences where practices have had providers that aren't really interested in learning much more about the coding process, the documenting process. But I think we've had success when we've had conversations with the auditors and legal counsel and, Ericka and I getting on there and saying, look, we get this is boring. We get this isn't the practice of medicine. We get all of this. But at the same time, here are the consequences if you don't listen. And I think when you really get down to it and explain to people, money is going to be taken back. Maybe your employment agreement says that they're going to take money from your salary if money is taken back from the practice because of your actions. That's nobody wants to be hit with a financial penalty for their work. And also, really, if you've been told 2, 3, 4, 5 times what you're doing is wrong and you consistently do it anyway and allow it to be billed, where does that rise to the level of purposeful intent? And does that lead us over the line of what the government might see as a fraud concern? And when you get into those areas, now you're looking at more significant penalties. And as you mentioned, Elizabeth, the potential dreaded orange jumpsuit, for criminal penalties. So I think, there's a lot to work with clients when they have a compliance plan. And I think all the pieces between the audit end and then what you do with that audit really need to come together for it to be meaningful and effective.
Right.
I couldn't agree more with that. And allocating your resources appropriately is going to be important as well. If you're in a large organization and you have this top tier performer providers, if they are consistently hitting 95%, 98%, 100% on their audit, but then in the same organization over here, you have the 40s and the 50% and the 60%, obviously they're going to need more attention than your top performers. So knowing where to allocate your resources and the types of conversations that you need to have. I worked for an organization once who actually had a tiered program like that. And, the 40s and the 50s got an audit every 30 days, whereas your top performers had one maybe every 12 to 18 months. So that's really important as well, knowing where to pick your battles, if you will.
Right. I've seen language like that in contracts as well, and that's
Mm-hmm.
absolutely works well, obviously, for larger organizations. I think smaller ones where they're doing a lot of stuff themselves is where I
Mm-hmm.
think it's hard. They have to wear a lot of different hats. And
Mm-hmm.
so, Christina, one of the things you and I struggle with is when we get these compliance plans in place, and then we see the results of the audit, and then we really need to have a conversation with the client about what we do with the results. Do we wait and hope that next time is better? Do we see these results and say, well, from the moment you know that you overbilled or underbilled or used the wrong modifier, that's information that you're supposed to do something about. As you mentioned, we can fix it going forward, but what do we do now that we have that information? And so typically we'll talk to the client about their options and what the government wants you to do, which could be, a self-disclosure. Sometimes it's a simple, oh, we made a mistake. We found this in an audit. Here's the money back. And sometimes it's a little bit bigger than that. And so I guess I'm curious from both of you about the conversations you have with clients, how often they listen to you. I know in my experience, I'll definitely put it in writing and about what my recommendation is, but often they're going to take a chance that nobody's going to find out. They don't want to refund any money unnecessarily is what they call it, right? Mm-hmm. So can you speak to that, both of you, from your different perspectives after kind of going through this process?
Okay. So once again, I have the situation where it goes very, very well, and then it can go completely sideways. And I've had that happen in the very same practice before, where I've gone in and I've educated, and you just have that dream provider who is curious about coding and wants to make sure that they have it absolutely right. I mean, from personal experience dealing with them, I'm sure these are very type A people. They're not used to being told they're doing something wrong.
Right.
And so the reaction is just that. It is extremely emotional and extremely volatile. And it's, how dare you come in here and tell me what I'm doing wrong? I had a provider use those words. How dare you come in here and tell me how to practice medicine? And I went, no, sir, that is not here. That's not why I'm here. I'm here to teach you how to document medicine, the exceptional care that you're giving to your patients. I want to make sure that it makes its way onto paper, because E&M University defines MDM as the cognitive thought process that a provider puts down on paper. So I need to make sure what is going on up here makes it to here, and that's what I'm here to do. I don't want to jump over into clinical world and make the assumption that you went to school for 10 plus years to learn how to treat your patients. I've had the same type of education, it's just in different aspects. So again, approach is going to be very, very important. Then you have those providers who, it doesn't matter what you say, they're just going to be like, nope, I'm not going to listen to you. I don't have any time for this. Do you have any idea what I have to keep up with on a daily basis, et cetera, et cetera, et cetera. And at that point, you very clearly delineate, this is what's going to happen if you do not take our advice. We're coming in here with the nice approach. So if you don't want to listen to us, there is absolutely escalation that can and will happen. And I'm here to tell you right now, you're going to like me a lot better than you will them.
And that's really sort of, similar concept to, I think, what Ericka and I deal with when we're educating clients and advising them. I will say most of the time, even though you get some providers that can be a little hard-headed at first, generally they do the right thing. They do what they know is required by the law. It may be grumbling to do it. It may be dragging you to do it, but they'll do it. But Certainly I've worked with providers that say, I'm going to roll the dice. It has happened in the past. We fix it in the future. We've never been audited. We don't think we're going to be audited. I'm going to roll the dice. And I always explain to people, I can tell you what the law says. I can tell you what your legal obligation is. And I can tell you what happens if you make a choice not to follow that legal obligation. But I can't make a decision for you, and I can't make you do anything. I can't. Nobody can make anybody do anything really, but a court. And even then they have a hard time. You make a court order and people don't, comply with it. So you can't make anybody do anything. But I always make sure I'll tell you the consequences based on your choices. If there's choice A, follow the law, choice B, not follow the law, my advice is always going to be follow the law. But if you don't want to, here's the road you're going to go down with B. And here are really all the bad things that can happen. And it's not meant to try to scare people. It's meant to educate them and say, I don't know what's going to happen. You may be right. You may be retired from practice and it never came up and you won, you beat it. But it also may be that next year they audit you, they find this, they found out you knew about it. Now you're going to be in trouble. And that trouble is going to be financial penalties, or depending on the circumstances, it could even be criminal penalties. And traditionally, I think providers are educated enough and understand enough to, while they may not want to do the right thing, will follow the choice to do the right thing, but you can't always ensure that'll happen.
Right. And I think there's a real distinction between large organizations where their compensation is tied to compliance. They can be terminated or, have their compensation reduced, for, penalties or fines or whatever. There's lots of variation. But when we come to a smaller independent practice, they're very, they take everything very personally. It's their practice and they feel like they take extraordinary care of their patients, which they do. And so you're right, they can take it very personally. And it's really important, and it's something we struggle with, is that we're their allies, right? We're the first line of defense. We're educating them, helping prevent this from happening. And then if it does happen, we're trying to show them how to minimize the damage, how to respond. And Christina, I know last time we were all together, you mentioned, one of the biggest, or maybe it was today, one of the biggest fears is about whistleblowers. And one of the things we see very commonly is that billing person who either told the doctors they weren't doing something correctly or tried to get them to change something. Maybe it came out of an audit, maybe it didn't, maybe it was internal compliance, and they don't listen, or they keep doing it wrong. Or actually sometimes there's those billing people that just go from practice to practice and look for those issues and sure, just professional whistleblowers too. But it's pretty scary for those physicians that are trying to do everything right. They're trying to have a compliance plan, self-auditing, doing the best they can, to know that somebody in their very office can be ready to get them in trouble. Have you had that happen at all with anybody, any of the billing staff that you've worked with at a practice? Or do you ever kind of get the sense that somebody's feeling like, look, if you don't fix what you're doing wrong, then we're going to go to the government instead? Have you ever come across that at all?
I have once or twice, and honestly, those people are coming from the best place. The few that I've had interaction with, they are coming from a good place. They don't want to be, I worked really hard for my CPC credential. I don't want it taken away from me because I didn't do something right, but this provider's just not listening to me, blah, 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 blah. And you kind of have to talk them down a little bit and say, all right, I understand where you're coming from. I understand this is a big deal. It is very, very serious. The consequences could be very grievous for your provider. There are steps we can take before we get to that point. If you feel like you have exhausted all of your resources and you're still not receiving the resolution that you think is appropriate, then I can't tell you not to do this. But you have to understand that you are probably going to be called upon to potentially testify if this makes its way to court. Are you comfortable doing that? And when you start spelling out the way things may go down for them, they kind of back up a little bit and say, okay, and two, understanding if it's just coming from personal frustration and there's kind of a vindictive spirit behind it. Obviously, we don't want to get into those types of power struggles, if you will.
Sure. And I think one thing that providers need to be aware of is, in a practice, no matter who engaged in the activity that was not appropriate or didn't meet, Medicare, if we're talking about Medicare or provider guidelines, it's really the providers, particularly the owners of the practice, that are going to suffer no matter what.
Yeah.
I mean, it's to your advantage if your biller tells you, I think this is being done wrong, or for you to sort of audit your billers and see if they're doing things that aren't appropriate that you maybe weren't aware of. As an owner of a practice, as a provider, you're charged with knowing what's going on in the practice and knowing what actions are happening. So at the end of the day, you can be considered responsible for the actions of your employees, and also any financial penalty is going to come from taking money back from the practice. The government's not going to take the salary away from the biller. So it behooves providers to always sort of know what's going on in the practice, through these audits and through listening to employees who say there may be issues and taking those seriously. Because at the end of the day, the defense of, well, I didn't do it and I didn't know it was going on, doesn't work. It's problematic for sure. And we've had clients that have been in those shoes who truly did not know and were not the bad actors, and who wound up in bad circumstances, and their biller just left. The one who did the work,
I think that's a great point, Christina, because billing and auditing is just one part of really a robust compliance plan. That's really what we're talking about today. But when Christina and I work with our clients and their compliance plans, we're talking about billing, but we're talking about other things as well, whether it's kickbacks or other inappropriate conduct. And I think one of the most important things is for people in a practice to be able to report what concerns them, to have an open channel to express that they think somebody's ordering tests unnecessarily, or somebody's documenting something wrong because they know they get better reimbursement. Whatever it may be, it may relate to billing or not. So I think, to your point exactly, is it's the owners of that particular practice at the end of the day that are going to be responsible financially, whether criminally or not really depends on their own conduct, but certainly not listening to what people have to say, hearing that it's going on and disregarding it puts everybody at risk. And, so this is such an important topic because, people do lots of things wrong in medical practices all the time, but there's really, in terms of getting caught, it very often starts with the billing component of it, because exactly for the reasons that you've described. But well, this has been such a great and helpful session. Are there any final thoughts that you want to share with us on this topic?
I think the best thing that you can do is realize that this is a concern. Don't think that it's a situation where, oh, I'm just going to ignore this. I don't need a compliance plan. I'm 1 to 2 providers. Nothing bad's going to happen to me. You don't want to roll those dice. You truly do not in the environment that we are currently in with healthcare legislation the way it stands. Make sure that you have a program in place. Make sure it is solid. Make sure it's robust. Any doubts that you have, engage an outside auditing firm to fill in the gaps and the holes. And that's the best advice that I could possibly give you. A good defense is always what? Good offense, right?
Absolutely. Well, Elizabeth, thank you so much for being our guest yet again. It's great to have you here, and we'll definitely have you back in the future. And Christina, it's always great to be with you as well. And thanks everyone out there for joining us for the HealthLaw Hotspot, and we hope to see you back here again next time. You can check out more about Roetzel and Andrus at ralaw.com, and you can also see our other podcasts as well. Thanks for joining us.
Use of the Roetzel HealthLaw Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel HealthLaw Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.